There is no such thing as a perfect judicial system. National governments formulate their own concept of justice, taking into account national interest and the vector of development. Ukraine is no exception to the rule. The judicial reform began in Ukraine in 2016. Its goal is to radically change the justice system. The idea of the triumph of justice should be the basis of decision-making, including the court decisions, or the idea of the prevalence of common sense, if you will, combined with justice. The judiciary system has been changing since the moment Ukraine became independent. The judicial branch was on the rise in 2004. Back then, society entrusted the judiciary with the adoption of an extremely important decision, specifically to determine who will become the president of the country. It seems to me that this decision even frightened some political forces. After that, there was much criticism and critical speeches were given. Unfortunately, the judiciary failed to react strongly enough to them at the time. Experts emphasize that thus began the weakening of the judiciary as a whole. It was followed by excessive politicization and the creation of an intact caste of judges who were in political put-up jobs. This led to judiciary losing the trust of civil society. Therefore, restoring confidence and increasing the credibility of judges is key to judicial reform in Ukraine.
Last year, a survey showed that 14% of the population trusted the court system. That is really not a level at which one can hope to achieve very much progress. The reasons for that are historical.
There are several stages of judicial reform. The first step on the path to change was the law on restoring confidence in the judicial system of Ukraine. For the first time, the staff got the right to elect a judge. In 2015, the law on a just court was passed, which addressed the issue of prosecuting judges, increased public participation and upgraded procedures. The third important step was the changes to the Constitution of Ukraine in the sphere of justice.
Constitutional amendments that were adopted by the Parliament on the 2nd of June of last year were perhaps the most significant legislative changes relating to the judiciary for a very long time. What they did, amongst other things, was reduce the power of the President and the Parliament in relation to the careers of judges.
Previously, the judicial system of Ukraine had 4 levels: local courts, courts of appeal, high courts and the Supreme Court of Ukraine. After the reform, the 3rd and 4th levels were united into one institution, the Supreme Court. It includes 2 components: 4 cassation courts followed by a jurisdiction: criminal, civil, economic, administrative and the Grand Chamber. For the first time in the history of Ukraine, people who have never been judges can be elected to the Supreme Court. There are lawyers, scholars, or those with mixed experience, academic work and practiced law, or combined judicial activity. They can apply for posts in the new Supreme Court.
І вони можуть брати участь і беруть участь до конкурсу до нового Верховного суду.
The Supreme Court may have no more than 200 judges, roughly 50 in each cassation court, and the courts choose 5 judges to the Grand Judicial Chamber from amongst themselves, plus the Chief Justice of the Supreme Court. Thus, the institution will have 21 representatives. The task of the Grand Chamber will be to ensure the unity of judicial practice in terms of cassation courts applying the same or similar provisions of the law.
Касаційними судами положень одних і тих самих або подібних положень законів.
So a tender was announced, so far only for 120 posts to the Supreme Court of Ukraine. 846 people expressed their desire to participate. 630 candidates were admitted to testing. 520 lawyers passed the test. 381 were invited for an interview. Having analyzed all the applicants and taking into account the conclusions of the Council of Integrity, the Commission chose 120 judges and sent a submission to the High Council of Justice.
Ми не останні,
We are not the last people in the chain of decision. There is also the High Council of Justice, which will receive our decisions on 120 people and examine them. If, for example, the Council has some reservations about this or that candidate, they can say, no, this candidate has no place in the judicial system. And I think nothing will stop them from denying this candidate a recommendation.
Судову систему. То я думаю, що ніщо їм не перешкодить відмовити в наданні йому рекомендацій.
Following the conclusions of the High Council of Justice, recommendations will be sent to the President of Ukraine. The multi-level system of judicial selection, based on a transparent tender, will allow for creating a professional Supreme Court, which should become a guarantor of fair legal proceedings for the people and the state level.